Good morning, students. In last video, we have discussed about the contract and the allied terms and some definitions of that allied terms. And little discussion we also done with that terms, legal terms. Now, in this video, we will talk about the essential elements of law of contract to make the contract in a valid form. Now here we can see the nine elements are there to make a contract in a valid term. That is offer and acceptance, intention to create legal relationship, lawful consideration, capacity of parties, that is the competency, and so on. Now let's start with the first, that is offer and acceptance. Now what exactly mean by offer? When we studied about the agreement is a combination of offer and acceptance, or the proposal and acceptance. That time I have discussed about, I have explained the term what exactly mean by proposal is just a promise or set of promises which has been offered by one person to other person. That is what the offer exactly we can see. Okay, now for the purpose of making offer and acceptance, there must be two parties to an agreement. One party making an offer and the other party accept that the same offer. Okay, in last video we have discussed about the consensus ad idem. At the time of making the offer and acceptance to that offer, there should be the consensus ad idem. If there is absence of it, definitely there will not be considered as the there will not be the offer and the acceptance of it. And if there is no offer and allied acceptance or followed by acceptance, definitely there will not be any kind of agreement. So hence, one party making an offer and the other party accept the same offer. The person who makes offer is known as the offerer or the promiser. The person to whom the offer has been made, or we can say the person who receives the offer is an offeree. Okay, the person who only receive the offer is an offeree, and the person gives assent to the offer and accept the same promise, accept the same offer, then only he become the promisee. So if there is only offeree, there is no such kind of obligation for the performance. But if the offeree becomes a promisee for the offer, definitely he has some obligations to perform his part of contract. If he missed to perform his obligation, he may liable for a suit. Okay, now let's go for the next, that is the intention to create legal relationship. Students, we have discussed in last video about the category of agreement, that is legal and domestic agreement. Okay, now in case of domestic agreement, there is no any such kind of legal relationship between the parties. But in case of legal agreement, sorry, but in case of legal agreement, there must be the legal relationship between the parties. If there is no relationship, if there is no legal relationship, the agreement may not be considered as the legal one. And if there is no legal agreement, the agreement may not convert into the valid contract. So if there is no such intention, the agreement may not convert into the contract. And agreement of social or domestic in nature do not contemplate legal relationship. Now let's go for the next, that is the lawful consideration. In a very short meaning, we can say consideration, that is something in return, or else we can say an advantage or a benefit moving from one party to another. Fine. As we discussed in the first element, that is offer and acceptance. So if one person making offer to the other one, in that offer, against to that, or in the response of that offer, if we are getting some consideration, that means if we are getting consideration, that is the offer has been accepted by the offeree. Okay, so this acceptance, we can say that there is a consideration. Now again, the thing which is important, lawful consideration, that is acceptance should be in the manner the acceptance should be in the manner that it can be enforceable by law. Okay, the promise which does not get something in return will not be enforceable by law, hence there should be the consideration. We can say that the agreement which followed by the consideration, hence we can see it is a valid contract. So consideration must be real and lawful. Okay, real and lawful, it should not be the vague one. जर असं झालं तर मी असं करेन, उद्या पाऊस पडला तर मी माझं परफॉर्मन्स कम्प्लीट करेन, अशा स्वरूपाचं कन्सिडरेशन तिथे मुळीच नको आहे. नेक्स्ट इज द कन्सिडरेशन मे बी ॲक्ट ऑर ॲब्स्टिनन्स. ॲब्स्टिनन्स दॅट इज to stop to do anything. Okay, to stop to do something or to stop to do anything, that is the abstinence. Act or abstinence, or the promise to do or not to do something. Like if suppose you have any kind of differences with your friends, and the person asking you about your notes. Okay, so in that case you deny to help him regarding the notes, and even you talk to your other friends to not to help that person with whom you are having some kind of differences. So such kind of promises are considered to be the consideration to the offer or consideration to the agreement. The next is consideration may be past, present or future. Student, just keep in mind this point, because consideration as a separate part of our unit we are going to discuss in next videos. Okay, now we will go for the next, that is the capacity of parties, that is the competency of parties. Now students, it is really the very essential element of the valid contract, because if the parties are not capable to understand the terms or conditions of the contract for the purpose of performance of their obligations, definitely they may liable for suit by the other party. Okay, now what kind of capacities the person should have? Like the person should attain the age of 18, that is, a person should be a major one. The second one is a person should be of a sound mind, that is, a person should be live in present, or a person should have a presence of mind. Okay, next is the person should not be disqualified from the contracting by law. Now, the capability of parties to enter into a valid contract. If a party suffers from any flaw, the agreement is not enforceable except in some special cases. Okay, means this is a basic expectation when a party entering into the contract, that is, a person should attain the age of 18, the person should have sound mind, and the person should not be disqualified from contracting by law. Let's take an example of Sanjay Dutt. Okay, Sanjay Dutt, when he goes into the imprisonment regarding the allegations, we don't go about the allegations. So some kind of serious allegations imposed on the Sanjay Dutt, and due to that allegation, the court has disqualified him from entering into the contract, and that time whatever the films has been signed by the Sanjay Dutt, the production of that films has been stopped by the producer and the director of it, and such kind of things that happen when the person is not capable to enter into the contract. Okay, now what kind of flaws may be there due to which the person should not be considered to be the capable one to enter into the contract. Now flaws in the capacity to contract, that is, if the person is minor. Like if you are making a contract with kids, definitely will not be enforceable by law, but in some cases But in some cases there are some, what we can say, there are some liberal approach of liberal approach of the law. Just for an example, if a person is orphan, okay, if that kid is orphan, that time the kid has been adopted by some people, and that people consider to be the guardian for that kid. Okay, so if anyone wants to get into the contract with that minor, definitely that time the person has to deal with the guardian. So this is the special case which makes the contract enforceable. But if you are making a contract with a sound mind, with a very clearance approach, and if and making a contract with a minor, definitely it will not be enforceable by law. Okay, now the another part of the flaw, that is the lunatic, that is a person if not in a sound mind position, or the person may not having the presence of mind. The such kind of person may not be considered to be the capable one to enter into the contract. If the person is idiot, okay, in a general way we say many people as a idiot one, or we may notice some people as a idiot one. But basically idiocy is a serious term which may create depression or the anxiety in the person, and in that case the person may not be capable to understand the terms or the condition of contract, and may not be able to perform his obligation. The another is the drunkenness. If the person is completely drunken, definitely he is not in the capacity to enter into the contract. Okay, now we'll go for the next, that is the free consent. um, when anyone wants to enter into a contract, the person should have the free consent. Now free consent is what? Free is free. The word free means what? um, mm, the free is what, like, what I can say, there should not be any kind of burden from the other party to enter into the contract. Okay, and consent is what? The assent for the for that particular offer which has been received by some other parties. So the consent of the parties is free when they are of the same mind on all the material terms of the contract, with consensus ad idem. Now, where we can say there is an absence of free consent, if you are making a contract under coercion, like if anybody if anybody forced you on the gunpoint to enter into a contract, that is the coercion. The other part is the undue influence, that is if you have faith on somebody, and that other person is taking a undue advantage of your faith, and influenced you to make a contract, though you know that this contract may not be in your favor. So still you are entering into a contract, just because you are having a faith on that other person, and he is taking a disadvantage or undue advantage of your faith. Okay, the next is what? The fraud. If anyone is making fraud, or that is knowingly he is doing something harm to other person, in that case we may not say that there is a free consent of the parties to enter into the contract. Or else we can say, if there is a misrepresentation. Now misrepresentation, that is hiding the material facts about the information. So if knowingly any person hiding the facts, not only the facts, but we can see the material facts about some event or about some information, he is making the misrepresentation of that information. Now in that case we can see there is no free consent of the parties to enter into the contract. Next is lawful object. Definitely, if you want to enter into a contract, you must have a subject matter to enter. To enter into a contract or to making a contract with the other person, and that subject matter should be the legal one. Object of agreement must be lawful. Object must not be illegal, immoral, or opposed to public policy. Here we can see that a person a person who is going for the smuggling, that is the illegal one. A person who is knowingly doing harm to the other one, that is the immoral. Or the person if going for some kind of march or some kind of um, what you can say, some kind of union activities which making harm knowingly to the society, that all things will be considered as the unlawful, or these kind of things may not considered as the lawful object of the object of the contract. Okay. Next is the agreement not declared to be void. Okay. Again, we are having the same content as our different part of our unit, and we are going to discuss the different part in our next videos. But then just keep in mind that there are some agreement which may be considered as the legal one, but due to some flaws in that validity or the legality, the agreement may not be considered to be enforceable at law. Now, such the agreement which are not enforceable by law are the void agreements. Are the void agreements. So, if the agreements are void, definitely out of that agreement, if the contract has been formed by the parties, the contract may considered as the void ab initio. Ab initio, that is from the first part or first step of the act. Okay. So an agreement taught it might be though it might be possesses all the essential elements of valid contract, but the contract act specifically declares certain agreements to be void, like the agreement by incompetent parties, the agreement made under mutual mistake, the agreement made may have unlawful object or consideration, maybe as a whole or in a part, the agreement made without consideration, the agreement in restraint of train, the agreement is restraint of legal proceedings, the agreement have uncertain meaning, the agreement is a vaguer one, the agreement which is contingent on impossible event, the agreement to do impossible acts, that is जा जाऊन वाघिणीचं दूध घेऊन ये, ह्याला म्हणायचं impossible act. The agreement which has a second set of reciprocal promise is void agreement. So these all agreements we are discussing in the next video. Just in this video, just keep in mind these are the agreements which are considered to be the void and may convert into the contract and say that contract is a void ab initio. Now the last is certainty and possibility of performance. Sorry, second last is certainty and possibility of performance. So when you are going to make a contract with the other party, the object should be lawful. There should be the lawful consideration. The party should be the competent. There should be the free consent. All the essential elements should be there at the time of making the contract with other person. But if you are making a contract which is based on the uncertainty or the impossibility of performance, definitely it will not go as a valid contract. Now what is uncertainty? Uncertainty, that is which is not fixed, okay, or which is unpredictable. That is I will make my obligations, or I will perform my obligations if today the sun will not rise. Is it possible? Or else we can say, if today there is rain, okay, I will perform my obligation if today is a rain. In that case, due to the uncertainty, contract will not be in a valid position, or else impossibility of performance. Like, we can take an example of it. A agrees to sell, sorry, where A agrees to put life into the B's dead wife. The agreement is void as it is impossible of performance. Here we can see the certainty of, take example of certainty, that is, A agrees to sell B 100 tons of oil. Now in this case, there is no any specification about kind of oil, hence the agreement is void just for the uncertainty. Like, we are not we did not fixed the type of oil. The oil is uncertain to sell. And the last one is legal formalities. A contract may be oral or written. It is in the interest of that parties that the contract should be in writing. In some cases, some formalities have to be compiled with its enforceability, that is, to be stamped or has to be registered, or some statutory formalities. So, if there is a need to complete such kind of formalities, then only the contract will be the valid one. If there is no such kind of necessity of performing such formalities, then the oral agreement will be considered as the valid contract also. Okay, now here we completed the essential elements of valid contract. Now in our next video we will talk about the offer and acceptance in detail. Till then, stay safe. Thank you.